is Stephen Wagner. I'm with Rugby-Wishel. I serve as the town attorney for the town of Clifton. So tonight we're here under not your normal circumstances, so I've been asked to give a little bit of an explanation as to what we're doing here tonight and how the process will work out, okay? So we're considering this a resumption of the counting of the March 24th, 2026 municipal election. So as has been disclosed to the public.
I'm sorry.
Come on. Icebreaker.
All right, icebreaker. So thank you, everyone. So we're here today, as has been disclosed, two sealed absentee ballots that are presumptively valid. We'll go again through the validation process this evening. Were discovered the morning after the election had been counted and declared. We evaluated Title 21A and Title 30A, and you may be surprised to find that the law doesn't explicitly tell you what to do in these circumstances. So in my office, we evaluated case law, and we consulted with the Secretary of State's office, and under these circumstances, the best practice here is to resume the counting of just these two absentee ballots. They will then be valid and counted, will be added to the totals, and we will re-announce the results of the election tonight. And those will be considered the results of the election. So after tonight will be the day to request the beginning day for the 5-day period to request an inspection or a recount. So in terms of process today, there has been, since the announcement of this resumption of the counting, we did receive a written request from Cynthia Grant, one of the candidates for one of the municipal offices that could be affected by the outcome of 2 additional votes. The margin is such in all the other races and all the other articles that the counting tonight will not impact those articles. We will apply the votes to those articles. But as only the race between for Cynthia Grant and Steve Armenia was impacted, we received a request from Cynthia Grant to inspect the ballots. It was a timely request, consistent with statute. So the process will begin with allowing an inspection of the absentee ballots, applications, voter lists, materials. Once that inspection is complete, we'll proceed with a determination of the validity of the absentee ballots. That's the same process that the clerks and tally clerks here would go through during election day, and that was done on this ballot, but it'll be go through it again today. And once the ballots, if they have been declared valid, we will then proceed with counting the ballots consistent with the procedure for counting ballots on election day. Once that's complete, as I said, the moderator will announce those revised results. The ballot and all materials will then be sealed in accordance with the process for municipal elections, and we will then conclude this evening. So, with that, I would, and I should clarify, Cynthia Grant made an inspection, but we would also invite the other candidate if he would wish to inspect the materials.
It's not necessary.
Okay, thank you. So, Madam Clerk, I'll turn it over to you to coordinate taking out the 2 absentee ballots, all the other relevant materials, and then I would invite Ms. Grant to please come up.
Could I ask a question?
It is not a public meeting, so just like if we were conducting this as an election, we're not going to engage in a back and forth, but I will entertain if there's just a question on the process so that everybody is clear.
Right, that's the process with Title 21A on elections.
Yep.
On 791, it states that if a family member or a person that's a candidate can't turn in anybody else's ballot.
Right. So, sir, that is a legal argument essentially you're making.
I know that there is law.
Sir, you had your comment. I'm going to respond now, if that's all right. I'd like to keep a decorum here. So that is a legal argument, and there is a process for challenging a voter, and there is a process for an inspection, and there is a process for a recount, and there is a process for raising any complaints to the Attorney General. So you're welcome to do that, exercise those options. And in terms of the procedure tonight, it is, no, you can ask me a question on the procedure, otherwise it's out of order and we're done.
I was the monitor that day. I saw those ballots being delivered, and they were open envelopes. They weren't closed.
That doesn't appear to be a question on process, so.
So we're gonna let this go, even though it's not
No,
right?
I didn't. I announced to you the procedure that we'll be following, so we're done with questions unless there's a question on procedure.
I'm going to the Attorney General's office with this.
You are more than welcome to, sir. I've actually told you twice now tonight, that's the process you can follow. So, with that, yes, absolutely.
So, this person?
Yeah. Okay. So, do we have a
He was on the ballot.
we have a signature?
We gotta get his card out.
Could we get his card?
Yep.
Okay, so these are all applications.
Yeah.
Part of the validation process. Keep this discussion.
Be nice when not. Yes. No, she's really good at that. Her mom, I don't know if you ever met her mom. She's nice too. I do. I'm on a diet. I was a lot heavier.
This signature is I think it is. So, in light of that, so I checked that, allegation that the voter did not properly apply for an absentee ballot, or there was another violation of 21A, section 753B2 for a third person who was a candidate or a member of the candidate's immediate family picking up an absentee ballot is a valid grounds for challenging a right of a voter, challenging the ballot. The question I pose to you, Madam Clerk, is can the absentee ballots be validated based on that information?
No, they're gonna challenge that.
So let me, I'm going to check that as well. It's certainly grounds for a challenge, and so I would anticipate that you would be challenging.
Yeah, he never should have been able to push those up.
So can we process the challenge while I look at the statute? So the reason that matters is if it's simply a challenge, then we would still count them, but they would be marked as challenge.
They shouldn't be counted at all.
Right,
They
if
should be-
it's not valid, then they're not counted at all.
Right.
So I just want to verify if that's correct, that they are not valid, in which case we might count.
They never should have been issued with that.
Do you have any of the guidance on validating absentee ballots?
I think we have to keep them at the road cars and taking care of their voters.
You validate based on the signature of the...
We're not going to open it up to the public, that's not how this works.
Question was validated. That's not, they can do that.
Say that again?
Validate according to the signature.
Right, but the question here is whether the fact that it appears to have been picked up by a third party that is a candidate member of the candidate's family is the grounds for invalidating the absentee ballot. So, bear with me. Okay, so procedure on receipt of the absentee ballot, clerk should note the date and time and delivery, clerk to examine the signatures and affidavit. Signatures appear to have been named by the same person, the affidavit of witness certification are properly completed, the clerk shall write okay, and the clerk's initials on the return envelopes. That occurred on both of these, correct?
Yes.
When required, and the signatures be mounted in the name of the same person, this discrepancy is a result of the voters having properly in the system. The clerk shall attach each application where required to the corresponding envelope. Clerk is to open any return envelope. Procedure and receipt. there has been an issue raised, and the clerk has confirmed that the applications of the 2 absentee ballots appeared, it's been concluded that they were requested by a third person who is a candidate or a member of the candidate's immediate family. So according to state statute, absentee ballots should not have been issued. However, I have reviewed the processes for determining whether the absentee ballot can be validated, and I don't see that as a grounds for invalidating and not counting an absentee ballot. Instead, it is a valid grounds for challenging an absentee ballot. But according to, so what I recommend is we go through the process of marking that as challenged. It does not have to be the candidate.
It's not a challenge, it should be void.
So
It never
I
should be
don't.
issued to begin with.
So respectfully, I agree with you, it should not have been issued, but I don't agree with you that it can be voided and not counted. I'm not seeing.
And if it can't be issued, how can it not be?
This is not a public meeting. It should not have been issued, but then we have a 2-step process here. We need to determine if the absentee ballot is valid, and then we count it, but there's a process for a challenge. And what I'm saying is, you're right, it was, I am sorry. I do not see grounds for invalidating and not counting the ballot. Instead, we mark it as challenged, we process it, and then because that affects the outcome, there would be a recount.
But what I'm telling you is those ballots are not valid because they never should have been issued to begin with.
I agree with the
So
second
they
half of
shouldn't
what
be
you're
counted,
saying.
and they shouldn't be open.
If you can point me to something in statute that says we can't process it.
You just said
Never
that.
should have been issued to begin with.
There's nothing in statute that says you should do this right now.
Why did they be?
We just have to come
So,
up with.
we're not opening this up to the public. So, I determined that the ballot should be challenged. That does not have to be done by the.
Mr. Robbins, you need to be quiet, please.
I would please ask the public to be patient with us, to please reserve making comments. If you have complaints about my opinion on this, I'm sure you do, and there is an opportunity to challenge that. It's not interfering with this counting process. If there's any further interference, I will ask the sheriff to remove anybody who is interfering with the process. So thank you. I appreciate your patience. So I do not believe it's a valid grounds for not counting the ballot. I believe the ballot has to be counted, but I believe the ballot should be challenged. Now, the candidate who has raised this issue does not have to be the one to challenge it. Anybody here can. Anybody there can. So, do we have someone who's willing to challenge? I'm recommending that
Open
it be challenged.
2 ballots that never should have been issued to begin with.
Yes.
Wow. Which is going to defeat the purpose of trying to keep these people's votes private.
I understand.
It's not private. What they voted is going to be.
So, section 673 deals with grounds for a challenge. And this, the grounds for a challenge of the voters' right to vote would be that they did not properly apply for an absentee ballot. And that's what this is. This is an improper application for an absentee ballot. So it's grounds for challenging a voter. But then the statute goes on to say, the challenge must be made at the time the voter's being challenged, checking in. Challenge may be made against the absentee ballot after the name of the absentee voter is announced by the warden or clerk in accordance with section 759. The merits of the challenge may not be decided at the time the challenge is made, but only after the election, consistent with provisions of section 696. As soon as the challenge is made, the election clerk in charge of the incoming voter list shall write challenge, decide the voter's name on the list, and give the ballot to the warden. The warden shall write a number on the outside of the ballot. The warden shall also complete a certificate on which it appears the word challenged, the name of the voter challenged, and the reason for the challenge. The challenger and the warden shall sign the certificate. After the challenger has signed the certificate, the warden shall place the number that was written on the ballot in a conspicuous place on the certificate. Only the warden and the challenged voter may know the ballot number. The warden shall place the challenge certificate and the signed affidavit under subsection 1 in a sealed envelope marked challenge certificate, in parentheses, certificate number, and shall return the envelope until it is sealed with the ballot materials pursuant to section 698. The warden shall maintain a list of all challenges made. The list must include the name of the voter challenged, the name of the challenger, and the reason of the challenge. The list may include the unique number assigned to the ballot of the challenged voter. The list must be made available for public inspection after the polls close. 4. Proceed to vote. The challenged voter shall then proceed to vote in the usual way using the marked ballots. Regulation of challenger and challenges. A person challenging the right to another person to vote may not create a disturbance or obstruction. It may not interfere with or delay the challenged voter's exercise of the right to vote once the challenge affidavit has been completed. A challenger other than the registrar, clerk, or election official may not handle or inspect the registration cards or files or other materials except as provided by section 22. And
So let me add
can I
one
just
more
finish so we give everybody a complete reading of the section? In an election for federal office in federal or state court is issued in order extending time. I'll just represent this is not applicable here. 7, after the election in which a vote has been challenged, the registrar shall hold a hearing and confirm the qualifications of the challenged voter. The qualifications of the voter must be resolved in a reasonable time after the election. Voters may be either retained or canceled from the central voter registration system. So it's on the basis of that statute that I read aloud in detail, and I appreciate all your patience, that I'm saying this is listed as a grounds for challenging the voter's right to vote. And the MMA manual further provides guidance that where the challenge pertains to an absentee ballot, the absentee ballot should be marked as challenged and then counted.
So on another part,
Yep.
you don't think that that candidate ought to be made aware that he could be held criminally liable for doing this?
We're in a public session. The candidate is aware. If the voters are here now and they do not want their ballots counted, that would be another thing. So with that, I would recommend we have a challenge. It doesn't have to be the candidate, it could be any voter here.
I challenge since on counting of the ballots, since you said you
No,
stated.
excuse me, sir. I'm saying you can challenge the right of the voter to cast the ballot.
Well, this is about counting the ballot. It says in 695, it says must be completed within 24 hours. This is well past the 24
Sure,
hours.
sir. So I agree.
So I challenge that.
Yeah, so that's not a challenge to a voter, so your challenge is out of order. But I will repeat what I said previously, which is you're right. The statute doesn't speak directly to this situation, but we do have case law that does. And the case law I'm referring to specifically is Martin v. Waterville. The Supreme Court addressed a situation where a properly cast absentee ballot was not delivered to the voting place in time due to the failure of an election official to perform their duty. The court held that such a ballot should still be counted in a proceeding provided the voter is complied with all statutory requirements. So based on that case law, based on our reading of statute, and then based on our consultation with the Secretary of State's office, advised that we proceed with what we're doing tonight, which is the resumption to the voting. So bottom line, that challenge is out of order. I'm asking if there is someone who is willing to challenge the right of these voters to vote based on the errors that we have.
In the case law, it was mentioned properly cast votes.
Sir, I'm not arguing the point. You're welcome
This is
to.
what the case law you just read.
I understand. but I'm not arguing the point. This is not a public meeting.
So I challenge them on the ability to cast the vote. I just said I challenge the ability
Okay,
of them.
then you come up here, sir, and we need you to fill out an affidavit and explain the components that need to be on the affidavit. Okay, please. No, I just need one challenger.
It's not a property tax.
Right, the Secretary of State was told that it was.
We have to wait for it to go to the Secretary of State. Who rules on this wetland commission? Who gets to rule on, make this decision? I mean, it's so obvious what the answer is. It seems like you should be able to actually handle it.
Overregistered by the warden, so. The challenger's name, address, party affiliation, status as a registered voter.
That's still same.
Name, address, party affiliation.
Address is 7 German Turtle Road.
The name of the voter, the challenge, so. Are you comfortable with the challenge?
Yes.
Going out there? Next is the reason the particular individual being challenged may be ineligible to vote. And the specific source of the information on which the challenge is based. If you have in front of you, sir, section 673.
670.
This lists the reasons.
So, not properly applied for that. Yeah, just number 5 is the only one that's. I don't know what that was just on that.
So next will be a description of any additional information that you would support that.
Additional information that a candidate requested ballots, absentee ballot, where that would fall under 753-B, number 2A and 2E. This 2E says that any candidate, except for the candidate's own ballot. So these two, 2A and 2E.
And that's based on the review of the absentee ballot application for envelopes.
Question, on the outside of the mailing ballots, it says the clerk shall write or type in the name and residence address of the voter in the designated section containing the last, that included? It says, right, the residence address, no, it literally says
It says.
on 753-B.
Residence, Clifton, signature and name of voter, voting residence, Clifton.
Yeah, that's theirs, but in here it says,
Well, this is what we are providing for envelopes, it's the, we're asking you ballots.
I'm just reading along.
Yep, so go ahead.
753B, procedure for issuing absentee ballot. Upon receipt of application request, blah, blah, and it says the clerk shall write in the name and residence.
It's on the application.
It's on the application. The
On
application
the
is
return.
attached to the ballot.
They are, yeah.
On the return.
I see the return on there.
He's supposed to sign here. Signature or immediate family member returning the ballot. And you're the one going to sign.
Do you want to add that as a
Yes.
grounds for a challenge?
I said me, twice.
It's this part, yeah. The clerk shall,
You just, a suggestion would be just make a reference to.
just this one?
Yeah.
Okay, that's up to her on writing it. I will be perfectly fine.
Well, actually, it's active, it's not.
Okay, I will be perfectly fine with her just referencing that section. Okay. That's all I have for right now.
So, yeah, you can sign the waiver number. It's not.
I just wrote my stuff.
I'm going to print my name and then sign it twice.
Yes.
Just want to step back.
Yeah, if you don't mind, that'd be great, sir. Actually, can you come back to look notarized?
Yeah.
Can anybody else challenge the vote?
Don't need to.
Well, we don't need to.
Okay.
Who decides on the challenge? Where does it go from here?
Yep, so I'm gonna actually just read straight out of the elections manual once we get this notarized. And that'll answer that question.
Thank you.
I know, I've been looking at stuff in advance. It's the process, you open it up, you see what you have, and you deal with it according to the procedures.
It's long and extensive on all the writing. I used to have to read hefty manuals for the client, so. It's,
No, what I'm saying is I didn't look at that one.
oh, that's something.
So,
So that's part of the process.
right. That's what we're just following the process.
kidding me, I want to say. Striking voters. I affirm that that is my signature and name. And this, I affirm that this is my statement.
Thank you, Hillary. Thank you, Mr. Clerk. Thank you, sir. Yep. We'll return back. So what I'm going to do now, so that we're transparent about this whole process, is I'm going to bore you again by just reading through. This is from the elections manual by Maine Municipal Association. I have consulted the statute as well, and I find it to be in conformance with the statute. So, once the challenge has been made and the certificate filled out, the ballot clerk in charge of the incoming voter list must write challenged besides the name of the voter who has been challenged and give the ballot to the moderator. So let's take care of that step right now. So write challenged besides the name of the voter on the incoming voter list.
We can't challenge any other votes because we're just here for these two tonight.
That's correct. Thank you for the question. Okay, so challenge has been written on the voter list for both voters. The moderator then must write a challenge number on the outside of the ballot out of the challengers in public's view. So this is just a, please pick a number, write it on the two outside of both ballots. The moderator, yes. Place the number that was written on the ballot and stick this place on the challenge certificate. So if you could write the two challenge numbers on the challenge certificate, please. Okay. Moderator, can you maintain a list of the challenges made? So just the name of the challenger and the two voters.
Challenger, Greg, yes.
Name of the voter challenged, name of the challenger, and reason for the challenge.
Stephen, should that number be written on the actual ballot?
It should, yes, but I'd like to read through this next sections here. So, process for challenging the ballots is addressed in Title 21A, MRS 673 and 757. The ballot that has been challenged must be counted the same as a regular ballot. Its validity may only be considered if it may affect the outcome of an election. For example, if the margin of error of the votes is 2 votes, but 3 challenges were made, this would require resolution of the challenges. If the challenge ballots could affect the outcome of the election, then the envelope containing the challenge certificate should be kept sealed until it is forwarded to the appropriate resolution authority. 21A MRS 696-1. I believe that is the Maine Supreme Judicial Court, but let me confirm. The challenge ballot must be counted the same as a regular ballot. The validity of the challenge ballot need not be determined unless it affects the outcome of the election. If the change ballot affects the outcome of the election, the envelope containing the challenge certificate and the signed affidavit must be submitted to the Maine Supreme Judicial Court and its validity is determined, except when the final determination to affect the candidate governed by the United States Constitution. So it is submitted to the Maine Supreme Judicial Court for resolution. Okay, so I'd like to then, in my opinion, I think in these circumstances where the challenge was made before the ballot was open, we'll just put, and we're only doing one challenge, we'll just leave the marks on the outside of the envelopes rather than open up the envelopes at this time. I think that's,
You said we had to count them in.
sorry, what?
Don't we have to open the ballots?
No, so let me clarify that. So what I read to you was the statute that said we should open them and count them. And what I should have continued reading on to you all to explain where we have a case where it's determined that the number of challenges, and that's why we had to go through the challenging process. We have 2 challenges that would affect the outcome of one of the races. Therefore, according to the statute, we do not process the votes. We package everything up and we submit it to the Maine Supreme Judicial Court for resolution.
Okay. How long will that take?
I couldn't begin to guess. Other than I do believe the statute says it should be given priority.
Okay.
So that means we won't have a 4th select board person?
No, you have a declared election results. So those results remain results until the Supreme Court says otherwise.
Okay, good enough.
So if we could please seal the, make sure I get this right, the ballots, the challenge certificate, the list of challenges.
Speaker?
If you can hold on one moment. Cindy.
Yes.
Sealed envelopes, do we have sealed envelopes?
Shame on you.
This doesn't go in, this stays available for public inspection. We title this moderator's list of challenges that March 24th for this election.
Do you need to make copies of that before you seal it up?
So that sheet will not be sealed. That remains a public document, so we can certainly make copies.
Well, I'm just thinking for our records, because stuff does get lost.
I will ensure that the sealed envelope is processed. I wouldn't advise copies because it's not, it says it must be processed immediately. So,
Can you have more than one challenge?
no, in my opinion, we've had the opportunity for challenges was had, it was made, we proceeded to processing, so there will be no further challenges.
Does this challenge reflect that he's a candidate?
The individual challenge?
person that took over the ballots, does it?
Yes,
challenge
yes,
it?
we cited those provisions.
Check. And are you gonna see that get sorted out?
I So with that, the election results that were previously announced stand. Subject to this challenge process, but we can proceed with swearing in of. Do that tonight, or is that?
Can we do it tonight, please? We have 2 select board members right now, so it'd be nice to swear them in.
I defer to the clerk, that's your normal process.
Greg, you haven't been sworn in. You gotta swear in.
No, wait, before we proceed to that.
You have to do it.
Listen up, everybody, please. Before we proceed to that, can we please secure all the materials?
Lee Bryant.
She's fine. Wyatt. Looking good.
I simply pray to you, that I will support the Constitution of the United States and the state so long as I shall continue a citizen thereof. I simply pray and do swear that I will faithfully discharge to the best of my ability the duties incumbent on me as select board member for the town of Clifton.
I, Gregory Newell, do swear that I will support the Constitution of the United States and so long as I continue as a citizen thereof. I, Gregory Newell, do swear that I will faithfully discharge to the best of my abilities the duties incumbent on me as select board member for the town of Clifton until 2029.